So welcome back to this wonderful conference on customary international law and its interpretation. I take 1 second to thank again publicly Professor Panos Mercouris for inviting me and involving me in this very interesting project together with the other organizers, of course. And I will begin with without any further ado, the second panel for today. We have heard a lot about the difficulty of identifying the borderline between identification and interpretation of customary international law. This is a thin line with law in general, even for written law, but particularly so for customary international law. And we also heard about the tendency of international courts and tribunals not to delve in any depth in the mind-digging activity that is part and parcel of the identification of customary international law. There may be reasons for this, especially and not only the fact that judges themselves, especially if they have a heavy workload, may not be really in the best conditions to engage in what is a time-consuming and often difficult task. But there are other reasons. Maybe we will discuss them later on in the debate. There are, however, some patterns that international courts and tribunals take in performing this task of interpreting customary international law, and it is precisely on patterns and methods of interpretation that we will focus our attention in this panel. The first speaker today in the panel is William Worster, who is Senior Lecturer in International Law at the Hague University of Applied Sciences, and who will discuss the application of logic and reason in the interpretation of customary international law. I am very interested about what he has to say, and I think you will be as well. The floor is yours, Dr. Worster, please.
Thank you. Thank you so much. And of course, definitely thank you so much to the organizers for the invitation. This is a really special conference. I'm really enjoying myself, and I hope I can say something intelligent today and get everybody a little bit excited. Indeed, what I want to talk about is when is customary international law identified through logic and reason. And by that, I mean, of course, deductive logic and reason, as we've been talking about so far today. Rather than strictly following the state practice and opinio juris system that we've developed. I won't go into the distinction between deduction and induction because I think we've all talked about it so much today. Everyone is pretty well versed in that. So the part of the trigger for me thinking about this is this really curious passage in the Gulf of Maine case. So the court says there in one phrase that in order to find customary international law, it applies induction and not deduction from preconceived ideas. It's pretty clear about that. Now, I have some doubts about that because when I think about what induction is, I think about, what are the rules on falsification? What are the rules on sampling? What's the standard of proof? And I'm not really sure that the court is applying these kinds of things that we would use induction from, say, coming from the other sciences. But in any event, this is what the court is saying. But what's curious about this statement from the court is it is immediately following another statement that the court says, where it says that there are a limited set of norms for ensuring the coexistence and cooperation of the members of the international community. So what the heck is going on? It seems like the court is saying that there are two different forms of customary international law. There's one form that's limited for necessary cooperation, and there's this other form that we do this induction but not deduction. And it's very unclear what the court is meaning by that. And as sort of everybody so far has observed, the court is just not transparent with the kind of reasoning that it uses, and which times is it using this kind of approach or this other kind of approach, and what do we make sense of this kind of statement. So it seems to me that there are a number of instances when the court has essentially avoided the application of the two-element system. And I tried to make a kind of typology of these different instances. I admit right up front that these typologies are not particularly airtight because, again, the opacity of the reasoning sometimes is unclear whether the logic is this or the logic is that. But I'll give you just some ideas in some places where I'm seeing it and where I think that that maybe some areas are more justifiable and others a little bit more extended and more difficult to understand. So it seems like in some cases, the court is deducing customary international law from the rule itself, shall we say. So saying that here is an aspect of the rule, and this gets back to that difficulty you already mentioned, which is between interpretation and identification. Is it identifying a new rule, or is it just clarifying the content of the rule? I'm thinking, for example, of the rule of self-determination, Western Sahara, Wall Advisory Opinion, etc., where the court has to determine does it have an erga omnes nature, and that it can be deduced effectively from the existence of the right under customary international law. So is that a new rule, or is that just the same rule, but we're just figuring out more of what the content is? Burkina Faso, Mali, frontier dispute, uti possidetis, customary international law, because it's logically connected to attaining independence. This is just a natural conclusion. So there are these kind of instances where it seems that the court is just trying to find these new aspects of rules. But there are other cases. So sometimes the court is deducing effectively, in my view, customary international law from treaties. So Namibia Advisory Opinion, using the UN Charter to interpret the content of the right to self-determination, or armed activities case, right? Using the Hague Convention to determine customary international humanitarian law, etc. There's this really unusual case I don't see usually cited too often in this context, the territorial and maritime dispute between Nicaragua and Colombia. So in this case, it's really kind of strange that the court applied the UNCLOS procedural rules on the continental margin to Nicaragua, which was a state party of UNCLOS, in a dispute with Colombia, which was not a state party to UNCLOS. Strangely enough, both states had agreed that only customary international law would govern this dispute. So implicitly, I suppose, the court is saying that the procedural rule is customary international law. And Robinson picked this up in his opinion, saying that's exactly right, and this is not customary international law. So how is the court deriving this particular rule from treaty law? So those are a couple of instances, but there are other examples, I think, that start to really push the sort of scope here, or the degree to which we can sort of understand the use of deduction. And that's when this court starts to use deduction sort of by analogy from other rules of customary international law. So, I mean, I think most classically in the arrest warrant case. So looking at the immunities for diplomatic agents, heads of state, and then saying, by analogy, those must apply to a foreign minister because of these reasons, because of the functions of the office. Or looking in the Corfu Channel case, looking at the Hague Convention, 1907, and saying, indeed, this treaty applies in the case of wartime, but by analogy, it would apply in peacetime. So in a situation where it's not clearly covered by the rule. So that really feels like very much a new rule rather than just clarification of an old rule. And then there's a whole another bunch of cases where the court seems to be deducing the rule from legal principles. And I'm mindful of what Craig said earlier in the early session about general principles, and I won't go into all that. I think he covered that very well. But that the court sort of appeals to some kind of a legal principle and can use that to deduce from that to find customary international law. So think jurisdictional immunities case, principle sovereignty, principle sovereign equality, territorial sovereignty as a kind of underlying justification for immunity. Why is the court not just happy to look at state practice and opinion juris and be done with it? Instead, it's appealing to these other principles. Think about certain documents case, appealing to the integrity of legal proceedings. Again, where is state practice in the opinion of yours? Why is it not particularly relevant here? Pulp Mills case, precautionary approach, environmental impact assessments, so on and so forth. Sometimes it seems that the court is deriving this logic just because of the underlying purpose of the rule itself. So again, jurisdictional immunity, as the court says something like, the rules of state immunity fulfill an important place in international law and international relations. Well, that's great, that's fantastic, but why is that at all interesting if we are applying an inductive analysis to find customary international law? Or Gapchikovo, the stability of treaty relations is an important value. And I already mentioned, of course, Gulf of Maine case, this norms for coexistence and cooperation. But it seems like there are even other cases that, in my view, will go really to the extreme. And these are the group of cases that I sort of think of as the rule just makes sense cases. And that's the Corfu Channel elementary considerations of humanity, which of course is then picked up by Nicaragua case, cited again for customary international law basis for Common Article 3. Where is the state practice and opinion of yours that would support this? It seems to be completely unnecessary because the rule just makes sense. So how do I understand these kinds of this kind of approach, and can I build some kind of theory to explain this? So, as I said before, it seems like some of these can be explained by saying that we're just interpreting an existing rule. We're not looking for a new rule, and therefore maybe we don't have such a big burden of state practice in the opinion of yours. We're just clarifying something. It's just logically part of the rule that's already been codified, or rather already been prescribed through customary international law. But that's a little bit more difficult to understand in the just makes sense situations. And besides, of course, the court tells us in Southwest Africa cases, as well as Gulf of Maine, it says, we do not deduce the existence of rules. That's not something we do. There's always an inductive element there. And so maybe, is the court lying to us and telling us that they don't do any deduction, and yet they seem to be actually in practice deducing rules? So the way I think about it, and this is one area where I would really appreciate some feedback and some thoughts on this, I'm thinking about it that maybe what the court is doing is distinguishing between the existence, the constitution of a rule, and the evidence of a rule. Now, I am very mindful that that is a difficult argument to make, and I know that there's a significant overlap between proving the rule and the actual constitution and creation of the rule. But that if we can deduce that a rule makes sense through one of these various logical deductions, that somehow reduces our evidentiary threshold. So we require less evidence of state practice in opinio juris. I'm reminded of this, there's this hilarious, I think it's hilarious, statement in the fisheries jurisdiction case, Iceland, where the court said, when the stakes are not as high, international decision makers have not been so quick to find restrictive rules. When the stakes are not very high, what an interesting kind of analysis coming from a court designed to sort of objectively determine legal rules. I'm also reminded of Locke's dissent in North Sea Continental Shelf. So deduction is an alternative, in his view, to induction when the norms are difficult to prove. Now, I'm not sure that that's actually what the court is doing. I don't think the court is actually, and Tallman makes this argument as well in his European Journal article, that when the norms are difficult to understand, that we can sort of deduce, and that helps us to understand whether the rule is there or not. I'm not sure that's really right, because that would suggest to me that what the court would do is it would first logically try to do an induction, and when it hit a brick wall, then it would try to deduce. But I don't think the courts are really doing that. I think it's either deducing in the first place, or at least in parallel to an inductive analysis. So I'm not sure it's really exactly like that. Now, there are some other problems, I think, with this way of thinking about trying to explain this usage. One, of course, is in the Gulf of Maine case, the chamber of the ICJ seems to be pretty clear that there are two different views of customary international. This isn't just a way to do inductive easier, like a shortcut or something. And the other thing is that if you look at something like the Corfu Channel case, considerations of humanity, and the court looks at 0 state practice and opinio juris, if we're really just lowering a threshold of evidence, can we lower it to 0? Is that still applying an inductive process, if nothing else, just in name or even substantively? It also triggers, I think, some problems with the need to identify the content of the rule before we decide on what the evidentiary burden of proving the rule would be. So we would say, well, that rule just makes sense. Well, okay, but that doesn't seem to be a very objective way of doing it. So it does seem to me, though, that this distinction between the Constitution and the evidence could go some way towards explaining this. And I'm thinking about situations when, as an analogy, situations when the 2 states who are party to a dispute will agree that a rule of customary international law applies to their dispute. So, France, Djibouti in the mutual assistance case, agreeing with, or implicitly agreeing that the Vienna Convention on Law of Treaty applies to them. Neither one is party, but they applied anyway. And the court can apply it. It can use it as a rule of decision, even though it hasn't really been contested. Potentially, it could be wrong, but that's not seen as a problem here. I recall that Alain Pellet wrote an article, long time, right after the Nicaragua case, where he said that when states accept, well, of course, acceptance of customary international is not constitutive of it. We I think all agree on that. But that when states would accept the existence of a rule of customary international and their relations, it eases the burden of establishing the existence of the rule to dispute. Potentially, I guess, to little or no proof necessary. So, by analogy, I suspect that could be one way of explaining it. But again, I would very much look forward to feedback on how to understand that. So that's one batch of practice at the court where it seems to avoid the application of the whole element structure entirely, just completely shortcut it and reach a result on customary international law. Then there are a whole bunch of other cases where it doesn't, where it does engage with state practice and opinio juris. But and I'm indebted to Professor Westerman because I think she said it much better than I can, that the court already is using deduction to establish the parameters for how it would complete its induction. So deduction is already, the use of deductive logic and reasoning is already going to be part of, even when the court says it's doing an inductive process, and when it clearly is doing that. So the court has to deduce rules on framing the question. What's the burden of proof? Do we have presumptions? Do we apply the Lotus presumption? Are UN General Assembly resolutions a presumption of customary international law? What do we do about silence? What do we do about the principle of legality? These are all many of these very, very deductive exercises. And how do we do this analysis? When the court looks at this pool, this batch of practice, it has to do, I mean, if it's truly being inductive, it has to sample that, but it's not doing it randomly. It's choosing states that are more selective, or that are representative of the practice. Some states' practice seems to be weighted more heavily. So there are these choices that are going on in there, and as well as, of course, with the forms and types of evidence. Is the practice of states relevant? Is the practice of organizations not relevant? Why is the practice of organizations not relevant? The Michael Wood in his reports, when he discussed this question of can organizations' practice be used, cites no state practice or opinion juris at all to conclude that in certain cases we can use. He just relied on a sort of analogy with the rules of attribution under the draft articles on state responsibility. So there's a lot of deduction going on. Which acts of practice, which ones do we require the practice to be widespread and representative and consistent? How do we weigh the evidence, et cetera? I mean, I think we would all agree that it would be quite difficult to convince the ICJ to disagree with the ILC. If we think about all the different cases in which the court has cited the ILC with huge amounts of deference, that shows that the court has some type of deduction that this evidence is meant to be weighted much more heavily. So that even when, so we have this kind of shortcut, but even when we don't have this shortcut, there's a huge amount of logic and reasoning, deductive logic and reasoning going on behind the scenes, I guess. So I'll conclude here and just say that so the use of deductive logic and reasoning is I think just throughout all of customary international analysis, not just deduction. And we use deduction for weighing the evidence, kind of evidence, is the evidence sufficient, do any presumptions apply, etc. But that it also does appear to be a kind of supplementary approach, or perhaps substitute approach. And again, this is where I'm struggling with the sort of evidence constitution. But as a kind of substitute approach for the state practice opinions, when we can deduce it from other rules or from treaties or analogies, or perhaps even just where the rule makes sense. I'm going to stop there. Thank you.
Thank you very much for this very interesting presentation. There would be many comments on my side. I would just mention now a couple of things. Maybe I save more for the general discussion, but I think one of the points you make is very good in stating that courts shift their attitude, the ICJ, but also other international courts. It's not the same pattern that you have in every judgment. And this has to do, of course, with the personality of judges. This sociological element is always in the background, but also with the fact that I think courts think of their own legitimacy when drafting judgments. So they try to find the way of reasoning and of explaining their ultimate decision that may appear more convincing under the circumstances. I think His Excellency explained very well earlier that there is not a single approach to interpretation. There might be several. And I think one of the reasons is this, that you have to explain your decision properly and find the argument that is going to be more convincing, because this was also said in the previous panel, you have to convince your audience. It's not that courts create the law on themselves. They need to find their audience willing to follow. And that is, I think, one of the elements to take into account. Another comment, very brief comment on this, concerns what you were saying about the supplementary role that deduction may have. I find this quite illuminating in the jurisdictional immunities case you were discussing also earlier. It's actually one of the few cases in which the ICJ engages in delving with state practice. So I was a bit surprised to find that you had used it to the opposite, as an example of the opposite attitude. But yeah, it's a matter of finding all the arguments that can convince the audience and the parties. Speaking of which, I think you mentioned that often the courts do not deal with extensive analysis because the parties are in agreement with the existence of a specific customary rule, which actually is also part of the Gulf of Maine passage you were quoting. There, I think, is a problem in that kind of attitude, because the findings about customary international law that the ICJ makes have an impact on a much broader audience and the parties to the case. But I will leave this aside and just mention one last comment concerning Kofu Channel and general considerations of humanity. I have always read that passage as a finding of a general principle of international law rather than custom. And there you do not need to have state practice, at least not the traditional one, as a basis for a finding of an existing legal principle. But I have taken too much of your time abusing of my privileges as a chair. And I think it's high time to give the floor to our second speaker, Professor Stephen Wheatley, Professor of International Law at the University of Lancaster in the UK. And he will discuss with us the function of time in the interpretation of customary international law. again, we have a problem. I think he will go back to the problem of the divide between interpretation and identification of customary international law, but from a slightly different angle. The floor is yours, please.
That's great. Thanks, Serena, and thanks to Panos and the whole TRICI team for organising such a great conference. And I think particularly well done on the shift to a fully online event in such short time. So well done on that. I'm just going to try and see if I can get the technology to work. Oh, there we go. So what am I going to be talking about today then? So my presentation today examines the influence of the passage of time on the process of interpreting rules of customary international law. Ooh. Here we go. Now, the first problem for any discussion of the influence of time on custom is that scientists now tell us that the passage of time is not an objective feature of the universe. They reject the notion that time is a fourth dimension and that everything exists in time. The scientists point out that any account of time is really an account of change. We see a change from one year to the next with the passing of the seasons, a change from one day to the next as the Earth rotates on its axis, and a change from 1 second to the next by watching mechanical devices calibrated by reference to the frequency with which cesium atoms change from one state to another. The logical conclusion must be, therefore, that if nothing changed, then no time would pass. And what would it mean, for example, to speak about time for a meter in deep space where nothing ever changed? But we international lawyers do believe in the passage of time. And we believe in the passage of time for two reasons. One, and Eleni hopefully will like this point, because we believe that international law is a complex adaptive system. But we also believe in the passage of time because of our own personal experiences. We believe that this academic year is different from the last academic year, that today is different from yesterday, and that this session with Silviana, William and myself, which started about 15 minutes ago, was once future, is now present, and will soon be past. And we see reference to the passage of time in our conversations about precedents in terms of past practice, and the distinction that we identify between the lex lata, the law that is, and the lex ferenda, that is the law to come. And because we believe in the passage of time, we must also believe that customary international law can change both over time and also in time. So when we talk about change over time, that's the difference between then and now. When we talk about change in time, that's the difference between then and then. And I'll hope to pick out the difference as I go along. Now, hopefully, it's not too controversial to argue that customary international law can change over time, that we see customary international law saying different things on the same subject at different times. For example, the law on the territorial sea. And we see a change from one iteration of the norm, customary international norm 1, if you like, to another iteration, norm 2, where we see changes in the state practice or opinio juris. So it seems clear then that customary international law can change over time. But it's also the case that customary international law can change in time, that the law on a given day in the past can change in time, that something that was lawful then can change over time to being something that was unlawful then, with the benefit of hindsight. And the reason for this is the requirement for a period of transition between the old rule and the new rule. And this is explained by the rejection by the International Court of Justice of the possibility of instant custom. So we move from a position where we agree that the norm is norm 1. We then see some evidence of change and further evidence of change. And then we come to agree that the applicable norm is norm 2. That period of transition required by the ICJ means that custom changes over time. Now, during the period of transition, the old rule must be applied because there is no guarantee that the law will change. And the ICJ has made this point expressly so. So the law during the period of transition must be the law that reflects the old rule, Customary International Law Norm 1, if you like. And it's only when the law has changed that we can begin to apply Customary International Law Norm 2. But I'd like you to keep an eye on the third box at the bottom, Norm 1, Norm 1, Norm 1, and then Norm 2. Because after the period of transition, the law at that time changes. And the reason for this is that we can look back with the benefit of hindsight and we can identify the moment in the period of transition when the law actually changed. There must be a moment of change because custom cannot say different things on the same subject at the same time. It cannot, for example, be the case that there is a rule and there is not a rule at the same time. So with the benefit of hindsight, we can identify the moment of change. And that means that for that period in the transition, after the moment of change, but before agreement on the new law, the law has changed. The law on the given day in that period has changed with the benefit of hindsight. There has been no new state practice, no new opinio juris. The only thing that has changed is the element of time and the passage of time, meaning that we have to take into account the element of time in the identification of customary international law. We see this in the ICJ's Chagos Archipelago opinion. And in that case, the International Court of Justice accepted that it could rely on materials that post-dated the period in question in order to understand the applicable law. So in this case, to determine the applicable law in the 1960s, the court relies on the 1970 Declaration on Friendly Relations. Now, of course, we know that the Declaration of Friendly Relations was adopted, but international lawyers in the 1960s could not have known that the Declaration of Friendly Relations was to be adopted or its content. So my argument today is that this idea that time influences custom not only applies to the identification of custom, but equally applies to the interpretation of custom. That our interpretation of customary international law norms can change over time. There can be a difference in our understanding of the content of a rule then and our understanding now. But it can also change in time, that our understanding of what a customary norm means then can change with the passage of time. Now, just to give a bit of context to the discussion, and we've talked this in passing as we've gone through, I think we're implicitly accepting that there's a difference between identification and interpretation. That the formulation or identification of a customary norm depends on general practice or state practice plus opinio juris. And that has to be our starting point, that customary norms are identified by way of an examination of the available evidence of state practice and opinio juris. But I think we've heard it persuasively argued that the application of a norm or our understanding of a norm once formulated will often require us to interpret or make clearer what the words that we've formulated actually mean. And I think there's also an implicit understanding that a good starting point is the Vienna Convention of the Law of Treaties, which points us to examine the ordinary meaning of these terms, the context in which the rule is examined, the object and purpose of the rule, and also points us to systemic integration with other areas of international law. And of course, the Vienna Convention on Treaties points us to examine subsequent state practice. But there, I think we get an interesting blurring line, and I'd be interested to what people think about whether that distinction is tenable. Now, there are two ways in which our understanding of the applicable law can change over time. This is by way of evolutionary interpretation, where the ordinary meaning of words changes, and through a change in the technical meaning of words used in the formulation of customary international law norms. So if the ordinary meaning of a word changes, if the dictionary meaning of a word changes, then the customary rule must also change. And so, for example, the non-intervention rule is explained in terms of coercive interferences. So if the meaning of coercion changes over time, if the dictionary definition of coercion changes, then the rule must also change with it. Equally, if a technical term in international law changes, then a customary rule that includes reference to that technical term must also change. So my example there is reference to torture in the UN Convention Against Torture. If we get a clearer understanding of what torture means, then the customary prohibition on torture would also change. But I think a better example was provided in our keynote speech today, where His Excellency Judge Liu Dakan gives us the example of rape in the ICC statute as being a rule under customary international law, a rule covered by customary international law. So if the International Criminal Court were to define more clearly its understanding of rape, that must necessarily change the customary international law norm. And any customary norm that relies on a multilateral convention for its formation will change with a change in understanding of that convention. So we can see then that the meaning of a customary rule can change over time without the need for further evidence of state practice or opinio juris. So our interpretation can change over time. Our understanding of the norm then and our understanding of the norm now can change over time. But it's also the case, I would argue, that our interpretation can change in time, that our understanding of the content of the rule can change in time, that our understanding of the law then can be different at different points in time, without the need for further evidence of state practice or opinio juris. Now, the reason for this is in some ways self-evident, but is one of those insights that becomes, certainly for me, revolutionarily self-evident, that the process of interpretation takes place with the benefit of hindsight, with the certain knowledge that certain events have occurred or have not occurred. And this is information or data that could not be possessed by people in the past. Because the act of interpretation takes place from the privileged position of now, we make sense of the law then from this privileged position of now. And we see this also, again, in Chagos Archipelago. So in Chagos Archipelago, the ICJ had to decide whether the UK's detachment of the archipelago from Mauritius was unlawful at the time in the 1960s. They conclude that the right of peoples to self-determination crystallizes in 1960, and then they have to make sense of the content of the rule, to understand, to interpret the rule, and whether the rule applies to the whole territory or the territory can be dismembered in some way. The court concludes that the right of peoples to self-determination is to be understood, the content is to be understood by reference to paragraph 6 in Resolution 1541. But 1541 does not expressly say that. It talks about the territorial integrity of a country. So the court's judgment, its conclusion that the detachment was unlawful, depend on its understanding, its interpretation of the relevant rules. So what data does the court rely on in order to make sense of the relevant rules? Well, the data that it relies on is data that emerges after the crystallization of the rule. The court relies on data and information that could not be available at the time of the norms formulation in 1960. Now, why, you might ask, does this matter? Well, it matters for that very reason, that we have access to data and information that is not available to our international law colleagues of the past. So our understanding of the applicable law, of the content of how we interpret the law, will be different from their interpretation because we have access to data that they did not have access to. And that necessarily means that our conclusions as to the applicable law at that time will be different from the conclusions of our colleagues at that time. So when asked to interpret the applicable law in the 1960s, I think my sense is, and I can defend this if you like, that international lawyers in the 1960s would have A, concluded that there was no right of peoples to self-determination, and B, concluded that 1514 did not apply that principle to the whole of the non-self-governing territory. But looking back from the privileged position of now, we would conclude that because we have access to data and information which they simply could not have access to, because for them, that data and information was in the future. So I hope that I've persuaded you today that both the identification and the interpretation of customary international law norms cannot be undertaken without reference to the passage of time. We see a change in our understanding of custom and our interpretation of custom over time as the ordinary and technical meanings of words change, with the implication or the consequence being that our understanding of customary norms then and our understanding now can change over time. Hopefully that's not too controversial, but also our understanding of the proper interpretation then can change in time as we have access to more data and information because of the passage of time, because we undertake our analysis, our interpretation from the privileged position of now. And you can only do that if you believe that there is a now, that the passage of time is real, that events like this presentation move from the future to the present and now to the past. So I thank you for your patience and thank you for your time.
Thank you very much, Stephen, for this very interesting and compelling presentation. I wonder whether this problem with emerging new data is not something that international courts or any courts have to deal with constantly, and not only as on issues of interpretation. A judicial vision is a vision going backwards and not forwards. So it's something that happens also in other contexts. I think, for instance, thinking of the ICJ, of the whole issue concerning the status of former Yugoslavia as a member of the United Nations and the issue of standing before the court. There again, the court looked at events in the past that gave them an interpretation while very openly stating that the situation at the beginning of the proceedings involving former Yugoslavia was nothing but confused. So this is something that is really, I think, part and parcel of the judicial process. Another comment that came to my mind in reading your paper is that even if courts do engage in this kind of ex post reading of new facts and evidence, they tend not to admit it. They will not openly acknowledge it. The Yugoslavia example is rather an exception. They will tend to frame it as a convincing legal argument by somehow putting this part that you have been discussing so well in the background somehow, and maybe trying to conceal it. But I will not take more time, and maybe we can discuss further at the end of the panel. It is now time to give the floor to Dr. Silviana Cocan, who is currently a lecturer and Admit's Elevate Postdoctoral Research Fellow at the University of Montreal in Canada, and will discuss with us the topic of judicial dialogue between international courts as a method of interpretation of customary international human rights law. Please, Silviana, you have the floor.
Thank you very much, Serena, and thank you also very much to the organizers of this conference and for inviting me today to talk to you about judicial dialogue between international courts as a method of interpretation of customary international human rights law. So the outline of my presentation would be the following. I will first discuss the notion of judicial dialogue in the international legal order. Secondly, I'm going to focus on the customary international human rights law and its characteristics in my point of view. And finally, I'm going to address judicial dialogue as a method of interpretation and the perspective of jurisprudential objectivism that is arising from the practice of international tribunals. So first, when we have to define judicial dialogue in the international legal order, for sure, international bodies that are protecting human rights are both of a different nature. They are independent. Multiple legal systems protect human rights, either at the universal or regional levels. All those systems are coexisting together without any hierarchical principle of organization. So in this context, for sure, judges can be seen as autonomous and impartial interpreters that have the free willingness to open or not to external sources and to take the initiative to incorporate them in their decisions when they are constructing their legal argumentation or legal reasoning. So in this context, judicial dialogue can be defined as an interpretive technique that is based on a comparative method, additional to the general rules on interpretation defined by the Vienna Convention on the Law of Treaties at Articles 31 and 32. So judicial dialogue can consist for an international body in referring both to decisions or international instruments that are external sources to the system in which the considered body has to exercise its power of interpretation. It's for sure a spontaneous practice, so therefore is necessarily an asymmetrical practice. Moreover, in the absence of the binding precedence rule in the international legal order. So what we can see is that, for instance, in the Inter-American Court of Human Rights, the references to external sources is done on a regular basis, whereas in the case law of International Court of Justice or of European Court of Human Rights or of the Human Rights Committee of the United Nations, the reference to external sources is more rare and it more often intervenes to interpret key principles and fundamental case law. For sure, if we have a look at the Statute of the International Court of Justice and its Article 38(1)(d), judicial decisions are defined as subsidiary means for the determination of the rules of law. But I do believe that jurisprudence is a source of identification and of interpretation of legal norms rather than a direct source of international law. But especially international human rights law, I do believe that international judges play a crucial normative role. First, because many concepts and notions that are formulated in human rights treaties are formulated in vague terms and need interpretations to be applicable. And interpretation comes here as fundamental to determine the substance, the meaning, and the scope of the written legal rules. Second, the international judges also play a fundamental role in identifying the unwritten rules that can be considered belonging to customary international human rights law. And they also play, therefore, a role in defining their content. In this respect, I would link the notion of judicial dialogue to the notion of global interpretation through normative and systemic interactions, in which the context is particularly important, but also the object and the purpose in accordance with the Vienna Convention on the Law of Treaties. And when we have a look at the context, the object, the purpose concerning international human rights law, it is strongly related to the internalization of human rights protections following the Second World War. It's also linked to the aim to protect personal integrity and human dignity from the state arbitrary by limiting its power, and also to the realization of the universality of human rights, which is at the very foundation of this field of international law. Also, what I would like to highlight is that judicial dialogue can lead both to extensive interpretations, but also to restrictive interpretations. When we refer to extensive interpretations, what I mean by extensive interpretations is that judicial dialogue can lead to a self-expansion of the possibilities concerning interpretations by referring to legal solutions that were adopted in other systems. So, judicial dialogue as a spontaneous practice can highlight the existence of international common positions regarding certain aspects of human rights, whether substantial or procedural. So we can mention, for instance, the complementarity between international human rights law and international humanitarian law, the use Cogan's concept that encompasses prohibition on torture, slavery, genocide, racial discriminations, and the use of force by states, and also the binding nature of provisional measures that are indicated by international courts in legal proceedings in order to prevent irretrievable damage to parties. So, finally, I would also mention the extraterritoriality of human rights treaties that enlarges the state's jurisdictions beyond the principle of territoriality with the respect to the notion of control, exercise over persons or a foreign territory. What I would like to say is that those unwritten rules highlighted by international courts in their case law reflect a normative convergence in the protection of human rights. Concerning restrictive interpretations and judicial dialogue, as I've mentioned, convergent case law in regards to key principles and legal rules protecting human rights show that some terms will be approached in the same way despite the differences and characteristics of each legal system. But the use of external sources can also highlight disagreements, in which case restrictive interpretations are inevitable. So in this particular hypothesis, judicial dialogue would lead to self-limitation of the margin of appreciation and the power of interpretation of the interpreter, as the interpreter will spontaneously refer to external sources that are not binding or part of direct applicable law in its system. So in case of controversial issues, the reference to external sources can emphasize competing positions in matters of interpretation, and especially regarding customary international legal rules, such as the prohibitions of core human rights violations. And one of the most significant examples that we can mention is the trouble to determine precisely the effect of use Cogan's norms when grave human rights violations occur in an extraterritorial context and are confronted to customary international law on state and individual immunities and privileges. So the lack of consensus in the international community and regarding the effect of use Cogan's norms when they encounter immunities in international law will lead to restrictive interpretation respectful of a state's sovereignty, but neutralizing the binding effect that would normally be attached to a peremptory norm in any circumstances, even exceptional. So I think there is a permanent tension between the protection of human rights and the lack of consensus and in the international community, and also the opinion jurists of states that are very reluctant to more flexible and evolutive interpretations of general international law. The second point of my presentation, customary international human rights law in the international legal order. I think that regarding international human rights law, we can speak about a judge-made law concerning the content of international obligations, whether they are negative or positive, related to the protection of human rights. If you read, for instance, only the European Convention on Human Rights, you won't have the same definition of international obligations that are binding on the states as if you read the case law of the European Court of Human Rights that has been tremendously tremendously detailed and contributed to the development of international human rights law. So regarding customary international human rights law, I believe there is a reverse process in comparison with other fields of international law, that is, they are characterized by the emergence of customary international law rules first, that will be afterwards codified in international treaties. In international human rights law, customs seems to have followed treaties containing cross-cutting rules that were interpreted by international courts. So as we can see in the practice of international tribunals, some legal rules are common to all the systems, whether at the universal or at the regional level, showing therefore a state of substantial interdependency. Also, customary international human rights law seems to be strongly linked to jus cogens norms and erga omnes obligations. For instance, in 1994, in its General Comment 24, the Human Rights Committee emphasizes that provisions in the covenant that represent customary international law, and a fortiori when they have the character of peremptory norms, may not be the subject of reservations. So the Human Rights Committee gave a list of the customary rules found in the covenants, and the list is as follows. A state may not reserve the right to engage in slavery, torture, subject persons to cruel, inhuman, or degrading treatment or punishment, arbitrarily deprive persons of their lives, arbitrary arrest or detain person, deny freedom of thought, conscience, and religion, to presume a person guilty unless he proves his innocence, to execute pregnant women and or children, to permit the advocacy of national and racial or religious hatred, to deny to persons of marriageable age the right to marry, or to deny to minorities the right to enjoy their own culture, profess their own religion, or use their own language. What is interesting is that the Human Rights Committee never came back to this general comment and never really referred again in a new general comment that would be actualized, that would be more adopted in a recent manner. In the Nicaragua case, also, the International Court of Justice referred to Article 3, which is common to all 4 Geneva Conventions, as embodying rules which, in the court's opinion, reflect elementary considerations of humanity. And we know that this Article 3 common to all 4 Geneva Conventions referred to the core human rights that need to be respected and followed in any times and in any circumstances. Also, the ICTY in its Forunzia case ruled in 1998, using external sources and international legally binding instruments, arrived to the conclusion that the prohibition of torture has become part of customary international law and a jus cogens norm. It is interesting to mention that the European Court of Human Rights referred to the ICTY in its Aladzeni case in 2001 to recognize torture as a jus cogens norm, but in this particular case and in the following case law of the European Court of Human Rights, the foreign state immunity from civil actions always prevailed in extraterritorial violations of the prohibition of torture. To come back to the case law of the International Court of Justice in questions related to the obligation to prosecute or extradite case, the court also recognized that the prohibition of torture was part of customary international law, and it has become a peremptory norm, so jus cogens, and the court justified its opinion in regards to the fact that this prohibition is grounded in a widespread international practice, on the opinion of states, in numerous international instruments of universal application. It's interesting too that the court mentions the Universal Declaration of Human Rights, the Geneva Convention for the Protection of War Victims, the International Covenant on Civil and Political Rights, and also the General Assembly of the United Nations Resolution on the protection of all persons from being subjected to torture or other inhuman, cruel, or degrading treatment. The court also mentioned that this prohibition has been introduced into domestic law of almost all states, and that finally acts of torture are regularly denounced within national and international fora. So since some customary rules are not only customary, but they also belong to jus cogens and give rise to erga omnes obligations, such as the prohibition of torture, they should be binding on states without the expression of their will because of the nature and the substance of those rules, aiming to protect the human dignity and integrity and entailing concrete procedural consequences. It is also interesting to notice that very often in the case law of international tribunals, mentioning the prohibition of torture as a customary norm, the formula used is prohibition of torture and not the general one referred to in the UN Convention Against Torture, which is the prohibition of torture and other cruel, inhuman, or degrading treatment or punishment. So therefore, it's not really clear if the prohibition of those kinds of acts reflecting a minor gravity in comparison with torture also fall under customary international law, and could be qualified as peremptory norms in international courts' opinions. So concerning the strong link of customary international human rights law to jus cogens norms and erga omnes obligations, we see this also in the 2019 report on the peremptory norms of international law, in which the International Law Commissions outlined that customary international law is the most common basis for peremptory norms of a general international law. So I think that the uncertainty of customary international human rights law is linked to the indetermination of the effects that are attached to jus cogens norms, especially when they interact with other customary international rules, such as state immunity in front of foreign jurisdiction in case of extraterritorial obligations, violations of peremptory norms. And more generally, when one has to determine the procedural and substantial obligations binding on state that derived from jus cogens norm. And I also do believe that this permanent tension impacts negatively the coherence of human rights law, whether written or unwritten, alongside with not knowing if the content of customary international human rights law is the same as the rules defined in human rights treaties. So finally, seeing judicial dialogue as a method of interpretation and the perspective of jurisprudential objectivism, I think that through the practice of judicial interpretation in the international legal orders, customary rules emerge in the field of international human rights law, and they embody the hard core of fundamental rights that are both part of written and unwritten law. So a form of jurisprudential objectivism arises from the practice of international tribunals protecting human rights, as they are leading to strengthening spontaneous international law beyond binding written agreements based on the impartiality and independence of judges, because as we are speaking about binding agreements, binding obligations, I think that you cannot really rely to state practice or opinion jurists of states to be willing to respect their international obligations. States have signed, ratified treaties that they have entered into force. So through the practice of international tribunals, I do believe that some independent obligations arise from the judicial interpretations that contributes to define both written and unwritten law. For sure, political distrust or unwillingness to comply with the international obligations may limit the margin of appreciation and lead to negotiated judicial decisions, as it is the case to the effect of peremptory norms. But the existence of customary rules is not altered, but rather their effects are being neutralized until evolutive interpretation could prevail. I also believe that, as a matter of fact, there's a fundamental role that is devoted to national judges in interpreting and applying customary international human rights law, and also in applying ratified international treaties as they were interpreted by international bodies. Because if you refer only to the UN Convention Against Torture or to the American Convention on Human Rights or to the European Convention of Human Rights, and you don't take into account the interpretation that was given in the case law, well, the content of the international obligations of states is much more difficult to take into account. And moreover, the protection of human rights is the primary responsibility of state authorities in their domestic legal orders. When legal disputes arrive in international legal order, it means that something did not work really well at the national level. So I think this is something that is really fundamental, how to really apply effectively human rights norms into domestic legal systems. I also think that judicial dialogue can be seen as a process, and we can think about dialogue in a multidimensional manner, because it can arise between international bodies, between national judges and international bodies, and between national judges themselves, and they can contribute to the emergence of a network of an international judiciary. Also, concerning international human rights law, international bodies have tremendously contributed to defining norms of reference and minimum standards of protection that need to be incorporated into national legal orders in order to finally ensure the respect of human rights that belongs to national authorities. Finally, I would say that international human rights law, whether written or unwritten, aims to define limits to legislative, executive, or judicial powers, bringing them to act in accordance with the principle derived from the rule of law. But those norms of reference and standards for sure need to be taken into account by domestic state authorities. So for sure, the willingness of states is at the cornerstone of international law, and at the origin of the legal systems protecting human rights in the international legal order. But the notion of judicial objectivism that emerges from the practice of international courts might be strengthened in the following years if we think about a judicial dialogue as a long-term process and as a basis to this emerging jurisprudential objectivism, also as a tool to identify customary international human rights law through the case law of international courts, and as a tool to interpret customary rules in combination with the rules of the Vienna Convention on the Law of Treaties. I'm sorry if I've taken more than my allowed time, and thank you very much for your attention.
Thank you very much. You overstepped by really very little, and I think, and thank you for this very interesting presentation. I have just two comments for now, at least. The first one concerning judicial dialogue. It's true that it's particularly enhanced phenomenon in international human rights law. Again, I think part of the reasons underlying this care with which courts and also quasi-judicial bodies look at each other is a problem of enhancing their own legitimacy when they suggest evolutive interpretation or broad interpretation of the human rights norms they are called upon to interpret. I think you also pointed this out, that the development of customary international legal rules in the area of human rights cannot rely solely on cross-fertilization, on judicial dialogue, and on this mutual legitimation by international courts. There must be something else, and I think your reference to domestic courts is very much to the point here. It's not only governments that are involved here, also domestic courts can do a lot in order to confirm the interpretation that has come from international courts of given international human rights rules. One comment or question I have is specifically about situations which are quite frequent in international human rights, as regards international human rights courts, where a given court does not have it within its mandate to interpret customary international law. The mandate of human rights courts is often restricted to the interpretation and application of a given instrument. This is the case, at least, for the European Convention on Human Rights and the relevant court. It's not for all international courts. But I wonder if in this kind of situations, there might be a bit more than, an openness or eagerness to consider a judicial dialogue. And I think here of the Jones judgment of the European Court of Human Rights, where the court really did not delve and explicitly stated that it would not deal with state practice, opinio juris, or case law at large, because in light of the 2012 judgment of the ICJ in the jurisdictional immunities case, the balance between immunities and human rights law was set at a different level, and the European Court of Human Rights could simply had to take that into account. So I wonder whether issues of competence and applicable law have something to say or have a relevance in your discussion, and whether there are not situations in which a court is simply bound to take up the interpretation of another court and doesn't have much discretion in that area. But I've spoken long enough. I think it's time also for the other panelists and the audience to raise their hands or write their questions in the comments area. And then we have a round of answers. Does anybody wish to take the floor or to write the questions in the Q&A section? I see there is a question from for Professor Worster. Could it be that because of the just make sense thought, we already have some sort of conclusion solution in mind for the case at issue? And then wouldn't the exercise be more about finding the best suitable reasoning to get there, where inductive, deductive, analogy, precedential reasoning would be different analytical tools from which we can choose? William, please.
Thanks. Yes, possibly. I think that's part of the strange relationship of deduction and induction. Of course, the court doesn't ever really clarify to us which type of logical reasoning that they're using. We have to just sort of figure it out based on what the conclusions are that they reach. And at least in principle, I suppose we're supposed to think that they do everything inductively and that they reach these other kinds of conclusions. But indeed, I think that's, and this gets back to what Professor Westerman was saying in her presentation as well, that there's a kind of pre-baking approach whenever we ask ourselves a question. When we propose a kind of hypothesis about what the law, the moment you propose a hypothesis of what the law is going to be, you've already framed the discussion of sort of this possibility and its opposite. And there's no other possibility out there. And so when you have all this other state practice, then you say, well, that piece of state practice is weird and strange and doesn't fit into either one of the hypotheses that I've proposed already. So I just set it aside. When in fact, if we had a completely different way, a really truly inductive approach, perhaps we wouldn't approach it that way. But that's not really possible scientifically. You always have to have some kind of proposed solution. So indeed, yeah, I do think this is a curious relationship then between these two processes. But I do think that it does presuppose a conclusion. I think that the question is exactly right.
Thank you very much. I don't know whether Stephen or Panos raised their hands first, but I will just begin with Stephen because he comes first on my screen. I hope Panos won't mind. Please, Stephen.
So thanks. I've got a question for William and a question for Silviana. So to William first, this is a slightly unfair question, but I don't know if you're familiar with the debate on the rule of sovereignty amongst cyber lawyers, and if not, so the argument goes, states are sovereign. In the Island of Palma's case, Cuba says that sovereignty means the right to exercise the prerogatives of state to the exclusion of any other state. Therefore, all cyber operations by a state against another state are a violation of this regulative rule of sovereignty. It's a purely deductive argument. And I wondered if you had any thoughts on whether you think that argument makes any sense, whether you can get away with a purely deductive argument or not, or whether you need some evidence of induction, some evidence of state practice or opinio juris at the very least. And then to Silviana, you referenced the Human Rights Committee's general comment on reservations, where they come up with the most extensive list of customary human rights norms of anyone, and specifically rights of minorities being customary. I just wondered what your view of that list was, and whether you think it's helpful, unhelpful, influential, or not influential.
So I think it could be useful to hear Panos's question as well, and then we have a round of answers. Please, Panos.
If I want to be absolutely fair, William had raised his hand before me, so I think.
Okay, so William, off you go.
I had a question actually for Stephen. I love this idea of sort of always looking back and always trying to figure out. It makes me remember all these discussions about JCE, which are even more ridiculous because we're trying to figure out what was customary international law in the 1970s or in the 1990s or something, which is just even more. I wonder what your view would be on those two things. But my key question is the way that you're positioning the relationship between time and the ascertainment or interpretation of customary international law. It seems to make persistent objector completely impossible, because there could never be a point at which we would know. We would only know after, and so it would be completely impossible. But if we would accept that persistent objector has to exist, given the limits of our human frailties about knowledge and ascertainment, then persistent objector would be at the moment of ascertainment of the rule, not at the moment of state practice, right? That would be the sort of necessary implication. But then that leads me in turn to say, well, then, if that then is what we consider to be the moment of creation for persistent objector rules, then that's the moment the customary international law begins to exist, right? In a kind of whatever sense, that it, even though we had some of this formative practice, it doesn't exist until we know it.
I think I would maybe organize a round of answers now, and then we go to the further questions. Otherwise, we lose track, I think, of all these very interesting issues. So, William, since you are on screen already, maybe you want to answer the questions that were put to you, and then we go to Stephen for his own answer.
Sure, my answer is going to be really short because I don't really know a whole lot about this to be particularly intelligent. But from what you said about the purely inductive appeal to sovereignty, well, that does sound like things that other courts have proposed, including the ICJ, just coming from first principles and deducing it. In my view, though, it just means that that's a reduction of evidence. It shouldn't be that it's purely established as a primary rule. Coming purely from deduction. That would be just my reading of everything. And indeed, that we could reduce it to absolute zero. But then that also implicates what some of the other speakers, Serena in particular, had mentioned, which is that can implicate, of course, issues of the legitimacy of the court, and is the court just being purely arbitrary in terms of, and has it fully justified its underlying notions. I think that in the cases in which we reduce the level of evidence to nothing, I'm going to quote Morris Mendelssohn in his Hague Academy lectures, where he said something to the effect of, some customary international is just obvious, full stop. And it would have to be that kind of a case. I'm not really sure that the sovereignty cyber is just that plain obvious, though.
Thank you very much. Then maybe Liviana can answer a question, and then we go to Stephen. Silviana, are you there? Sorry.
I'm here. Yeah. So first, concerning the right of minorities and the position of the Human Rights Committee, I think that the list given in 1994 was particularly broad, and especially in regards to very few case law at that time in the international legal order. That's why maybe the Human Rights Committee never really came back to this list and never really referred to it in an extensive manner. Concerning the right of minorities, I don't know what to say, to be really honest. I think that some elements may be part of customary international human rights law when they are related to jus cogens norms, such as the prohibition of racial discrimination and kind of really the broad principle of discrimination. But according to all the elements that are related to the rights of minorities, I think there are very much a lot of trouble to determine precisely if all this it's really part of jus cogens norms and as part of customary international human rights law. But I'm really willing to hear you if you have any thoughts on it. I'm just being honest. I don't really know. And I would like just to come back to what you said, Serena, at the beginning with the jurisdiction immunities case. It's really interesting because when we envision the prohibition of torture as a jus cogens norm, first it was the ICTY that defined the prohibition of torture as a jus cogens norm and as being part of customary international law. Then the European Court of Human Rights in Al-Adzani case in 2001 referred to the jurisprudence of the ICTY to adopt the same position, but to not conclude that there was a conflict between jus cogens norms and the immunities of states. And it's really interesting to read the dissenting opinions of the judges that were part of Al-Adzani case, because the solution was adopted only 9 positions in favor, 8 against. So it was really a contested decision. And what is really interesting is that the International Court of Justice, 10 years after, in the jurisdictional immunities case, extensively relied on the European Court of Human Rights case law, saying that it was an established precedent, while it was not at the time that it was adopted, and to finally conclude that there was no conflict between the rule on immunities and the jus cogens norm, because one is of a procedural nature and the other one is of a substantial one. But if you consider that there's no there's no conflict between those norms, then for sure everything falls apart. But it depends how you see it. But if you have a look at all the dissenting opinions of the Al-Adzani case, you see that for the multiple judges there was a conflict between those norms. And afterwards, it's interesting that the European Court of Human Rights confirmed in Jones its initial position, referring to the International Court of Justice. So it's really, for me, those cases are an excellent example of judicial dialogue that is being built, and the cross references between international courts that contribute to define a certain standard that's finally really not that doesn't bring coherence to international norms protecting human rights, and finally that contributes to blur the effect that should be attached to jus cogens norms. Thank you.
Thank you. And now, Stephen, you may answer, and then we go to the next round of questions.
So I'll wrap up Serena, your comments and William's comments about the backward-looking nature of adjudication. And I think it's true that courts don't stand on the roadside making instant judgments about what's happening and calling it as lawful or unlawful. So that it's always going to necessarily be backward looking. And I suppose that for me, it's like the doctrine of intertemporal law directs us to ask a series of questions. So we've asked, well, what happened? And then we're directed to ask, well, when did it happen? And then we're directed to ask, well, what was the applicable law then? And that's where we stop traditionally as international lawyers. And for me, there's another question that we've got to ask. When did we ask those questions? And you might then say, well, so what, just playing with notions of time, and there's an interesting debate about the philosophy of time. But actually, I think as hopefully I've persuasively shown, is that sometimes, depending on when we ask those questions, we will come to different answers. And so if the applicable law can change depending on when we ask the questions, then we international lawyers can no longer simply take time for granted, that it is Thursday, that it is, whatever time it is with you and whatever time it is with me, that we've got to factor it into our discussions. In terms of William's question about persistent objector, I think that's a great question, which I don't have an instant answer to. I guess for me, persistent objector, you've got to object at or around the time of the crystallization of the norm. But of course, if the determination of the point of crystallization is going to be determined by an observer at some point later in time, if they draw that line well before you start objecting, then you're a subsequent objector, and therefore, so that's a great comment, and I'll think more about that.
I could take a point here, but I first have to give the floor to Panos first, and then Eleni. Please, Panos.
Serena, such great restraint. You put me to shame. I would have asked the question myself. So thank you.
Behave. I'm just trying to behave and resist temptation.
Thank you very much, Serena. And thank you to all the panelists for the very, very interesting presentations. I had a number of questions. First to William. I was glad that you mentioned the Gulf of Maine case, because it's really, I mean, you mentioned the passage about the inductive, then even more so later on, and then they go even further, where they basically say that, you know, a body of detailed rules is not to be found in customary international law. So what do? Let's make a better formulation of it. Essentially, so they're basically saying, let's interpret this stuff and figure it out how it's done. But my question is more closely related to what Stephen asked, basically, because Germany recently released, I think, a paper, or I don't know what the official title of the government document is, about the application of humanitarian law principles to cyber operations. And there, what they basically said was, in no uncertain terms, is there is no state practice or opinion on this matter. However, it's a matter of interpretation, and we do think that logically the IHL principles should apply in cyber operations. So that will be my question to you in this sense. What are your thoughts on this? Then to Stephen. Yeah, I mean, the reference to time, absolutely fantastic. It also reminded me of the quote by, I think I want to say Friss, but I might be completely mistaken, that the time does not change us, it merely unfolds us. And your discussion on how the rule has changed, but we realize it at a much later point, might be kind of an application of that. One question there that I might be inclined to ask is, since you focused on time also from a scientific perspective, that then could we also consider that, similarly as with the two-slit experiment, that it's not just about the time, so the changes of customary international law in time and through time, but also the matter of its observation. So who is actually observing whether a customary law exists or not, and whether that does affect the content or not. So whether the act of observation and the actor, the observer, actually affects this. And the final question, of course, to Silviana. This judicial dialogue is very near and dear to my heart. What I wanted to ask you is your thoughts on, so yes, you mentioned the domestic courts actually do, take into account customary international law. So this is very in conformity with the idea of consistent interpretation. But sometimes you see domestic courts actually reversing that order and essentially interpreting international law so that it's okay with its domestic rules. So would like your thoughts on that, whether you think that this is an okay process, is it problematic, and how do you see it going in the future? Yeah, thank you very much.
Thank you. Then we have further questions and comments in the chats, but I think I will give the floor to Eleni, because I think she raised the hand before these questions, and then we go to the written comments.
Okay.
Eleni, please.
Thank you, Serena. Just a short comment. As Stephen was supposed to say about time, could you please just comment, if we have time again, your notion of in time, not within time. because as Panos just said, the question is twofold: whether who observes what happens, who interprets, and then again, speaking on my own experience on terrorism and the case law, the Special Tribunal for Lebanon said something very, very interesting for me. It said that we have to look after time at when the act was committed, but the time of commission of the criminal act is not. It's not certain. We have the act, we have the effects. So where do we put the commission? In time, within time, what exactly could we define this in time? I hope it was a little bit clear, but anyway, we could discuss later if you're able. Thank you.
Thank you. Then I will read Professor De Hoog's questions for Professor Wheatley. Isn't the reasoning and or analysis of the ICJ in the Chagos opinion as to customary international law simply superficial? To wit, it does not engage with any examples of practice and the opinions of states where there was a certain separation of territories involved, e.g. West Papua from Indonesia, Northern Cameroons, to name but a few. And perhaps in addition, shouldn't we see the body of practice and opinio juris as being in a state of quantum flux? Because we can't know whether the rule exists until we have observed these, that is, analyze the relevant examples. In other words, Schrödinger's cat thought experiment applies to our identification of a rule of customary international law, in the sense that the rule does not exist, and at the same time prior to identification. Then we have the comments by Pauline Westerman, just a short note relating to William's contribution. Is it not necessary to think of theory-laden observations as deduction? It is not necessary, as deduction. We can try to discern patterns by making use of background knowledge without attempting to deduce or to derive rules from abstract principles. And then a further comment by Anders Follesdal to follow up on Pauline's good observation, another role of reasoning in addition to those addressed more specifically by some authors here. One way to secure reasoned coherence is to regard a rule as a permitted specification of a more general rule of principle. The specification is reasoned insofar as the rule is within various limits without requiring a deduction. The alternative specifications are underdetermined. So a lot of questions. I don't know whether we can exhaust these complex topics in the little time we have. We are pretty late on our schedule, but I would like to ask Silviana to answer first to questions put to her, and then we go in the reverse order as compared to the presentations for this final round of answers. Please, Silviana.
Thank you very much, Serena, and thank you very much, Panos, for your question. I'm going to try to be short. For sure, customary rules of international human rights law can be interpreted in a way that is consistent with domestic legal orders. And I think a lot of case law in front of international courts comes from a wrong interpretation of human rights law by judicial bodies in domestic legal systems, or by a wrong application of international law, or by the fact that it's not taken into account in judicial proceedings in front of domestic courts. So I think that how I would see this is I would like to refer to the Inter-American Court of Human Rights that has developed a really strong conventional test, because for the Inter-American Convention of Inter-American Court of Human Rights to consider that the obligations that arise from the Inter-American Corpus Juris on human rights are fully respected by domestic authorities. It has domestic authorities, and especially judicial tribunals, need to conform to its interpretations that is given in its case law. So I think this is really something that's important important in being conform to international obligations. And at the level of the Council of Europe, with the mechanism of advisory opinion that can be now asked to the European Court of Human Rights by Supreme Courts, I think this says a lot on the will to minimize conflicts between domestic interpretation of human rights law, whether customary or deriving from treaties at the national level, that finally lead to violations engaging state responsibility. I hope that I answered your question. I tried to go fast, but thank you very much.
Thank you very much. Stephen, please.
Yeah, so thanks for the questions, everybody, and for the provocations. It's been really helpful. Let me just try and whip through and answer them briefly. So my distinction between overtime and in time, by overtime, I mean the law is different on different days, which is not normally problematic for us. When I talk about in time, and happily it would change it to within time, the law is different on the same day, the exact same day. And that for most international lawyers is an incredibly problematic concept, but that just is how the international law system works. In terms of the comments about the observers, yeah, I absolutely agree with that. I think, whilst I would argue that time is an invisible dimension, an invisible element that we don't talk about, everything we do has an invisible observer who's making sense of what it is that we're making sense of. And I think it clearly matters who is asking the question. And the ICJ's recent intervention on the meaning of race discrimination, and distinct from the Committee on Race Discrimination, I think is a good one on that. In terms of the court's reasoning in Chagos, I mean, my reading of the case, I do it in some detail in the Oxford Journal of Legal Studies paper. I think that's fine. I was mainly interested in the different ways the UK framed its understanding of time and the way the ICJ understood the notion of time, and trying to defend that. And in terms of the argument from quantum theory, I am fascinated by quantum theory, and my ambition is to understand quantum theory before I die. But I'm getting older, and it's not getting any clearer for me. I think the reason why not that, and Anthony Diamato from Memory's got a paper on quantum theory, is everything we've been talking about is around metaphor. And metaphors should help you make sense of the world. Quantum theory makes no sense. It is deliberately nonsensical to our understandings of the world. And so for that reason, I don't think quantum theory is a possible way forward, although Schrödinger's cat as a metaphor is a brilliant, it's both the law and not the law. I like that.
Thank you very much. William, you have the floor.
Thanks. I'll try to keep it as short as I can. I'll start with Panos's question. About the German IHL extension to cyber, without any citation to state practice. So in a way, your question is answered by Andreas's question, which is that if we can characterize the rule as simply clarification, this applies in normal IHL. This is just another kind of use of force, and therefore it's just IHL. What's the big deal? If we can characterize it that way, it would seem then that the burden is a lot lower. That, in contradistinction from saying, "Whoa, this is a brand new rule," then you feel like, "Oh, I've taken on a big burden." That is a really attractive argument, but I have to say I'm not sure if it's really convincing to me. So when I look at the various areas where, and of course I've just limited my observations really to just the ICJ. To all the areas where I think that the court is trying to do some kind of a deduction, it doesn't seem like the areas where it's having humble deductions, it's somehow easier than the areas where it's making really aggressive deductions. It seems to me that, and again, I'm trying to make the argument that this is just a question of evidence, which means it's just a question of, are we convinced at the end of the day? And different things can be more convincing than others. And the idea that when you have these kinds of arguments, these deductive arguments, that can somehow lower your burden. So if, for example, the Germans said, hey, this rule makes total sense, and here are two cases where it happened, we might all just say, that's great, that's perfectly enough for us. Saying there's absolutely nothing, I'm a little bit more hesitant about, but I wish I could come up with a sort of much more, mathematical, shall I say, approach, but I struggle to do it. I mean, ultimately, it's a weird dynamic because we are trying to figure out the content of the rule before we assess our expectation of the evidence for it, which is to me a sort of such a backwards way of thinking, although maybe I have to stretch my mind a little bit more to embrace it. But so that's my attempt at an answer to both of your questions. For Professor Westerman, yes, I totally get what you're saying about are these necessarily all deductions? I'm sort of leaning on the definition of a deduction that I'm sort of borrowing from Talman when he used it in the European Journal, among other places, and really more sort of the way it tends to be used more in some of the sciences, where because indeed deduction can have, I follow you, a much more specific meaning within law, but I think that I'm not going to be able to give you a particularly intelligent question. I'm going to need at least a couple of days to think on that one a little bit more. But your point is well made and appreciated. Thank you.
Especially if we are talking about coherence, then you think about
right.
mutually supporting
right.
things, not a top-down kind of thing
right.
or bottom-up, but you
right.
know, sort of non-foundational kind of imagery I have in
right.
mind. But
right,
okay.
right. Yeah, thank you
for your answer.
So thank you very much, everybody. I am sorry that we did not manage to stick to the time allotted for this panel, but I think it was worth spending a bit more time in this challenging discussion. And I look forward to more opportunities for that in the next hours and days.